you hear this repeatedly, read the trust, read the trust. You have to parse the trust. The trust is your guide, the thing that has higher control over what you're supposed to do.
Welcome to The Keys to Your Legacy with your host, Elijah Keys.
Well, hi, Susan. Nice to see you again. How are you today?
Good. Good to see you, Elijah.
Good to see you as well. I saw you recently at a conference and you had a whole table set up and you were giving away cookies. Is that right?
Yes. And I gave away the recipe too for peppermint chocolate brownie cookies.
That is a real big thing. Yeah. Your son was working at that table. Does he work for you full time?
He does. Yeah.
For you?
He's up in Tahoe, by the way.
Oh, is he right now? Okay.
Yeah.
So you are a professional fiduciary. What does that mean?
A professional fiduciary is someone who's licensed by the state of California, who is licensed to be trustee, conservator, power of attorney for other folks. And that comes into play when a family either doesn't have kids, like if a couple doesn't have children and when they pass, they need to have a successor trustee, or a lot of times fiduciaries come into play when there is a successor trustee that's a family member, but that family member is a child, and the child of the parents and their other children, and those children don't all get along. And so then it becomes contentious. And when there's contentious situations, a fiduciary is usually called in to be the neutral party, to behave as trustee, to act as trustee, to become the trustee. Sometimes they're appointed by the courts. Sometimes they just work through with the family and you're just assigned, the trustee may resign and then you are named the trustee. So it actually covers a variety of situations.
So it sounds like there's kind of two or three ways that you're appointed or you're named. One is that people voluntarily name you if they don't have anyone that they trust. So tell us about that process. Someone names you as its mate?
Yeah, I don't have a lot of those, but some, like for example, there's a couple in San Francisco that I work with and they got my name from an attorney. They don't have any kids. They got married late in life. Neither one had been married before. So they're in their 70s, 80s. And so they're asking me to be their trustee. So when they pass, I'll pass on their assets to beneficiaries. In other cases, I'm trustee actually of a woman who is still alive, but she's had a couple strokes, has some dementia, and I was called in to be her trustee so that I could manage her affairs while she's still alive and then distribute her assets after she passes. But all we did was go to an attorney to straighten that, to set the documents up and make me trustee.
So it sounds kind of like you are a surrogate family member, a surrogate child, surrogate aunt. You basically serve for the family almost like a family member in those cases.
Yeah, in those cases where it's not court appointed, you're just associated with this person through the documents, and the documents are put together by an attorney such as yourself. Mm-hmm. So I've had several cases like that where a woman had, she didn't have dementia, but she didn't have any family. Her husband died of, I think he died of Parkinson's. Her two kids died of multiple sclerosis. And so she was alone and she had assets, and she wasn't in independent living. And then she had some issues and then she had to move to assisted living. And I took control of the move, making sure that she was taken care of, making sure that she got all her furniture moved over, that some of her assets, some of her personal items, such as beautiful glassware, just a lot of personal items that she wanted to make sure got to certain people before she died. So then I did that. I took her list and made sure I contacted the correct people to make sure that those items got to the right people.
Yeah.
So like a piano went to her chaplain. So things like that you take care of.
Well, that's kind of the peaceful thing. So anybody who's listening who might not have a family member they might want to consider, or someone that they trust, they consider a professional fiduciary. You said that you serve in several roles. Can you define those, kind of talk a little bit about the different times and different things that you might do for someone?
Yeah, thanks for asking that question because it's varied. In one case, I just wait until somebody passes and then I manage all the paperwork to distribute their assets. And a lot of times the assets go to nonprofits. So that's a very common thing that people do. While they're still alive, I am not just her trustee, I am also a power of attorney for her estate and power of attorney of her health. What that means is that when she, for example, fell and had to go to the hospital and broke her hip, then I can go to the hospital, I can talk to the doctors, and I can work with her on her behalf to make sure that we understand together what the doctors are telling her, what she has to do. And it gives me legal authority to be able to hear what the doctors say. The doctors won't talk to me because of HIPAA rules unless I have some legal authority that is associated with the person. There's that. I have a special needs case where I am pretty much everything to this guy. I have to look out after his hygiene. I have to look out after where he lives, how he is getting benefits from the state. That's why I go to the special needs conferences, because he's a special needs man. He's 80 years old. He cannot take care of his finances or where he lives. He can't cook, those sorts of things. He can't read. So I manage pretty much everything, getting his assets from the state where he is under the regional centers. Maybe this is getting too detailed, but the state has these regional centers that supply housing funding to people with disabilities, intellectual disabilities. And so I work with them to get his benefits properly allocated to him. I had to deal with Social Security as well to make sure he got SSI, to make sure that he got those benefits properly set up. So there were a lot of issues that a fiduciary has to take into account and act on behalf of that other person and make sure they're well taken care of.
Yeah. I mean, it sounds to me like, if I'm just going to restate that, it sounds like you kind of take care of someone's personal and financial life when they can't do it anymore. And that can be substantial. Just in my life, I have a bunch of bank accounts and I have a bunch of business things, and we have a house and we have a mortgage. And so all of these circumstances that in my mind might be really simple just because I've experienced it and I have so much background with it, someone really has to have a lot of expertise to take over, if I'm hearing you correctly.
Yeah. So there's also two sides of that coin as well. There's helping someone that does have adequate assets to take care of themselves. So if somebody, for example, is in assisted living and they have enough money to pay for assisted living, there's the flip side, which is in my case, in this special needs person, he has no money. So that's even more challenging because now you're dealing with agencies and federal support and state support and making sure that money comes in. And that's a whole different situation that you really need a certain number of skills and you need a big team to help you with that sort of thing.
For sure. Yeah, I can see that happening. Well, let's switch to the flip side, where we not talk about where someone voluntarily chooses you as a representative, but where you are forcibly chosen as a representative, which happens with warring families. It's a little uncomfortable, but let's talk about that. What's your role? Because that gets juicy, right? It gets juicy, it gets meaty. You have skeletons come out of the closet and sibling or they're just attacking each other at the throat. What happens?
Exactly that. They're attacking each other at the throat. I mean, I've had several of those cases. They're very, very tricky. Usually there's litigation involved. I don't believe you should be doing X and that money goes to me and I believe I should get everything. So there's a lot of drama too. It's not just the hostility, but the drama that gets in the emotions that get enmeshed. And you have to stay, as trustee of these kinds of cases, you have to stay neutral. And again, sometimes it's a challenge because sometimes there's folks that you can have a regular conversation with and reason with, and then then there's other folks that you can't reason with. And so it can be very dicey. And that's where attorneys come into play too, that can be very, very helpful and support you as the fiduciary to make sure that you are following the letter of the law, because you can get sucked into emotional things and you have to be detached, stay detached, follow the trust instrument, follow the law. And so there's a lot that a trustee has to pay attention to, and is almost, sometimes it feels like you're an attorney. I felt like in the past 5 years, I feel like I've almost gotten a law degree just, going to education from having been in so many situations, contentious situations that I've had to deal with.
So let's paint a picture here. Okay. So we have a family with 4 kids. Let me just paint a picture of recent case that came out of my office. 4 kids, all 4 are named as co-trustees of a trust. One child lives in the home. She feels that she gets to live there as long as she wants because she's the trustee. 2 of the children want to close up the trust. 2 of the children want it to remain open so that the daughter can continue to live there, basically indefinitely. And they have this warring situation where things start getting more and more heated because one side expects the money from the house. The other side says, I get to occupy it. You can't take me. You can't kick me out. And they just start warring and they are attacking each other. This is a small estate, by the way. It's less than $2 million in comparison. Sometimes I've seen estates 15, 20 million and people are attacking and they're warring. And so each of them hire an attorney. There are 4 attorneys involved. I represent one of the parties. And now we have 4 lawyers all arguing in court. And every time someone wants to make one small change, all the lawyers attack. How do you fix that?
I don't know if I'd want to.
Well, in general, in my experience, what happens in that situation is judges in my field, probate judges, they do not want to see people coming back to court repeatedly, time and time and time again. They don't want people attacking each other for ridiculously small items. And if somebody's mad, they will attack over everything. Some people, not everybody, some people have the type of personality that if they feel threatened in any way, they attack en masse as hard as they can, regardless of whether it's rational, reasonable, or right. They just attack no matter what. And they go their full force, claws out. I'm sure everybody listening knows somebody like that. And imagine that type of person being your opponent and knowing every time you, as a child, make a decision that affects another child in any way, that they're going to attack you. You're the person that is appointed, that comes in, that basically stays neutral between them so that they don't attack each other. Is that right?
Yeah. So as you're talking, I'm thinking, okay, if I were crazy enough to step into that, the first thing I would do, get a good attorney for myself, number 1. Number 2, read the document, read the trust instrument, because we go to training a lot as fiduciaries. That's another part of our licensing process, is that every year we have to have so many hours and credits of continuing education. So you hear this repeatedly, read the trust, read the trust. You have to parse the trust. You have to look at subtleties in the trust, but the trust is your guide. That is the thing that has higher control over what you're supposed to do. And then it comes the law, the probate law, trust law. So that's the first thing. Just read the document. And that then is your cover for whatever decisions you make. And if somebody gets mad, this is what the trust says. I mean, your coverage is, this is what the trust tells me to do. So those are not knowing what the trust is, not knowing the whole situation. I don't know what my next steps would be, but those would be the major things. Is we just need to go by what the trust says.
And it's kind of a weird legal circumstance or a weird way of thinking, but trusts are not written for people. They're written in advance for judges. Because if something goes wrong, if people follow the trust and everybody gets along, it's a guiding document, but it's there to say what's supposed to happen. Trusts at the core are legal contracts written to enforce people's wishes. And what you're saying now is you're saying you are going to follow the contract because because you know that people are likely to attack you. If you step into a contentious situation where people are mad, suddenly you become the black sheep. You become the very convenient target that everybody's going to go after, regardless of whether you do a good job or not. And if I hear you correctly, what you're saying is, I need to follow the trust document because in the end, if somebody's going to attack me, they're going to run to the judge and they're going to accuse me of doing something. And the judge is going to look at the document, is going to say, what did the person who created the trust, what did they ask you to do? And you say, I did this. And the document says exactly the same thing. And the judge says, what's the problem? I think that there's kind of a circumstance where you might choose to take a case or not because of who the attorney representing the family member is, whether that attorney is experienced, whether they're reasonable, whether you believe that you can trust based upon their pattern of behavior, whether they're going to attack you for reasonable or non-reasonable things, right? If you legitimately make a mistake or if they're just going to do whatever the angry family member says.
Another thing that comes to mind as you're talking is how old is the trust?
Yeah.
So for a fiduciary to accept a case and the trust was written in 1999 and never updated, that's another red flag because language changes, the law changes, interpretation changes. That's something that would have to factor into it. And this is something I would recommend to listeners is that if your trust is old, please call Elijah and update your trust.
Well, call a reputable attorney. It doesn't have to be me. But talk more about that. Why is it important that a trust is updated within the last 5 years or so? What sort of things have you seen gone wrong because the trust was old?
Somebody got married, even though they were still a beneficiary of the trust, because later a relationship developed and they got married. That didn't get reflected in the trust. So that was a problem. I think also people will not go back and review who the beneficiaries are. Some of the beneficiaries either are gone or it could be a nonprofit that doesn't exist anymore. That's another reason. Language changes and the law changes. And so what I noticed in a recent one is, what does it mean to need tuition? That those words were parsed. Those words were attacked, right? What does it mean to need to have tuition paid if you're going to college, for example? It really the trust needs to be updated. And this is more like your bailiwick than mine, but just the vague language. There are things that attorneys recommend that you put into the trust nowadays that they didn't do 20, 30, 40 years ago, right? They didn't recommend certain language, certain clauses, that kind of things to protect the trustee, but also to protect the assets and also to protect the beneficiaries. And things like making sure that if somebody contests the trust, then what do you do if somebody contests the trust? I mean, nowadays, a lot of trusts say that beneficiary, anybody that contests the trust, they're disinherited. So there's those kinds of things that kind of help the trustee once people have passed, and now you're trying to figure out what they wanted. You want the language to be in line with how documents are interpreted today versus 40 years ago.
The reason why they're interpreted differently, you said this is maybe my area rather than yours. The reason why they're interpreted differently is because every single year there are committees with California state, and every single state in the country, there are committees that talk about problems with every area of law: insurance, education, contracts, corporations, real estate, trusts, my area. And so there are entire committees of attorneys that say, look, there's a problem here with the way things operate right now, and we want to fix it. We want to correct it. So every single year, some of the laws that are passed in every single state are to fix those small problems. You deal with big problems first, and they deal with smaller and smaller and smaller problems. So over time, the law shifts. There are also court cases that redefine or clarify former practices. So when Susan says, hey, look, there are these prior practices that we used to do, but we don't do them anymore. Why did things change? It's not because people change. It's not because relationships change. It's because the way that the law is defined for that specific decision changes. Let's give one example of what Susan talked about. You mentioned something called a no contest clause. That's a clause in every single trust, almost every single trust, that defines what happens if someone objects. And it used to be that you could give a beneficiary $1 in a trust and have a very weak no contest clause. And then if the beneficiary objected, then you would have given them something. Therefore, they can't say that it wasn't fair. But the no contest clause law changed. It changed to say that, look, $1 is ridiculous. You can't say that you give a son $1 and then he doesn't get to say that this was unfair. Instead, if someone manipulated dad into creating a trust, then the son gets to say whether that's right or wrong. But now, if the son loses under present law, if the son loses that argument, then he loses his entire benefit under the trust, regardless of how much he got. It used to be that $1 was the practice because that law had not been clarified. Now the law is clarified. So if you look at an old trust, if your trust says, I give someone $1, that's because the law was different. Now, there are thousands of examples, and I literally mean thousands of examples, because there are more than 23,000 trust laws. So there are thousands of examples. Maybe some apply to you. Maybe they don't. Roll the dice. You can find out, or you can get it fixed. Either way.
Yeah.
It's interesting, though, when you're talking about being a fiduciary, why did you choose this profession? Because it seems like it's a very kind of niche profession. It's not a common thing to do.
I didn't even know about it until a friend of mine was a fiduciary. My background is in engineering. I was in mechanical engineering and vibration test equipment for many, many years. And as I was easing into retirement, so to speak, I was trying to decide what else to do because I didn't feel like I wanted to stop working. And so I started talking to a friend of mine who turns out she was a fiduciary. And so we just chatted about it. And I thought the way I got into it is kind of like a back door kind of a way. And I asked her about it. And she said, well, why don't you do accountings for me first and see because I'm an engineer. I do spreadsheets. I like math. I'm good with numbers. I was okay with that. So I said, all right, I'll try doing accountings. And so, we can talk about accountings in a bit, but accountings are very specific method of doing numbers and accounts for a trust and estates and conservatorships that is not in line with what CPAs do or like tax accountants or corporate taxes or corporate accounting. It's got a very specific set of laws on how to do that. And so I started doing that. And then I thought, well, if I'm going to be doing accountings, let me get licensed. And so I can kind of be more in line with the people that I'm doing the work for. So it helped me understand what they're doing, what they're dealing with, that sort of thing. So that's how I kind of got into it. It was just a backdoor kind of thing. A lot of people that get into this kind of business got into it through being social workers or nurses or working in public guardian offices, working with attorneys or paralegals, that sort of thing. So people that had some experience with the field before jumping in and getting licensed, but that didn't happen in my case. I came through a side door.
It seems to me like you're talking about kind of a secret world that exists below everyone's consciousness. That when people lose the ability to make decisions for themselves, there's an entire secret world down there of protections and restrictions and people who operate in this very dangerous place where some people who are not protected have millions of dollars stolen from them. Last month, I had a client that called that said, would you please help my dad? He's lost $3 million to a Bitcoin scam. $3 million. And I said, this is what you need to do. And she said, I don't think we're there yet. He still has $1 million left. What do you mean $1 million left? He lost $3 million. It was stolen. Well, he says that he can still manage things himself. No, he can't.
Oh, God.
But okay, that's fine. But there's this whole world that seems to happen when people lose the ability to make decisions. and it's focused entirely, completely on protecting that person from being hurt in a lot of ways. And to operate in that world, you just need a certain level of training and expertise, and it is not easily understood. Is that fair?
That's fair. And I think it also requires a certain level of caring.
Sure.
While you have to be detached in some ways because you have some number of clients, and if you get too emotionally attached, it can get very emotionally gut wrenching. But at the same time, you really do have to care. I mean, in my example, I have a client that's got partial dementia, and I need to protect her assets. That's my job, is to make sure that she has enough money to live until she dies. I don't care as much about her beneficiaries. If there's money left over, I care about her beneficiaries. Her money right now is for her to live, and to live in a way that is with abundance, and make sure she's happy and she's well fed, and she has a lot of, she has what she needs and wants. So it's an interesting mix of being rational and on top of things in a way, and then also caring for that person as well. And you're right, there's some very disturbing behavior that people perpetrate on seniors, especially if somebody has dementia or is partial dementia, or it's very disturbing, like this guy losing $3 million. It's so frightening. And the sad thing is if he thinks he's still okay, there are challenges there, because the laws say if he's not been deemed incapacitated, there's not a lot you can do.
He gets to make bad decisions.
Yeah.
And you're right. You're absolutely right that you have to care, but you also have to be, as a professional, you have to be somewhat detached, because I've had plenty of clients who died, and I cared deeply about their well-being. And then when they died, they were no longer clients anymore. And my assistant, one of my assistants in my office, the first client that she had helped died, and she was in tears. And it was very jarring for her. And I'm sure that it was that way for me as well when my first client passed away. And she said, Elijah, how can you handle this? You knew them for years. You knew them for 10 years. They were very close to you. They came and they called you every year. How can you not be affected by this? And I looked at her and I said, this is a normal Tuesday. We have people that die. And it's not that I don't care about them. It's about the fact that I need to do my job. And they don't hire us. People don't hire us to be emotionally laden. They hire us to do a job, which is to protect people. That's what we do. And so it's a hard thing to consider, but it also, you're right. The way that people need you and I to be present is to understand what needs to be done and to protect the person that needs protecting now, not yesterday. Yeah.
Yeah, absolutely.
Talk about choosing to trust, because what you've mentioned a couple of times is that you have a choice to take certain matters. I mean, you have a choice to take a case or not, to take a specific situation. And you and I have been involved in several cases, and some of them you took and some of them you didn't, right? And that's okay. That's your prerogative. And I don't have any bad feelings, positive feelings in any way. But it seems like you are very careful with the situations that you want to get into. Talk about the way that you make that choice. Why don't I ask a different question? Rather than talking about the way you make that choice, what are the factors that go into a decision like that?
Can it be resolved? Are the parties willing to talk, and can it be resolved? Can you see a light at the end of the tunnel? Yeah. If you can't see a light at the end of the tunnel, I would have a hard time taking it. If you think one person is particularly litigious, angry, I would back away from that too. I wouldn't touch that. Having had some experience, because I've had experience with that.
So let's think a third party point of view. They're thinking, look, Susan, you're going to be paid for your time. What do you care? You're going to be paid. The trust has plenty of money. It's going to pay you. Who cares if my crazy sister is going to attack you. Not to say that your sister is crazy, but to say that their motivations are different. They feel aggrieved, therefore they attack. They're the tiger lady. They come and they attack with claws out. So why wouldn't you take a case like that where there's someone who's just attacking everyone? What's the problem?
The problem is that you touched on it earlier, that instead of them butting heads themselves, the fiduciary then becomes the target of the hostility and the animosity and the aggression. You're not giving me what I'm supposed to be getting. And in that case, you have to feel your way through. Are they going to get an attorney and say that you're doing something wrong and then come after you legally? Or do you think that they're going to not take that far a step because all that funds for defense and attorney's fees, that all comes out of the assets, right? That if somebody's going to come after you for something, it's coming out of the trust or the estate. But it's no fun. I mean, it's very, very, it's extraordinarily disturbing. It's not a good position to be in. I've talked to other fiduciaries who have had similar experiences, and it's very nerve-wracking to have to go through that.
So I'm gonna paint a picture here. So you have in my situation the 4 kids, and they're all attacking each other, and you say, I don't really want to be a part of that. And the reason why you would question being a part of that is because if they're first attacking each other, then you become the bad guy, and they might start attacking you. And the only way that you can defend yourself is by spending the money that is eventually owed to them. So they are hurting themselves by attacking you for needless or reckless reasons. So you have to defend yourself by hiring a lawyer. You hire a lawyer, you spend the money from the trust to defend yourself as the actor of the trust. And the children or the beneficiaries who are attacking you, they're attacking you just because they want to attack someone. Maybe they feel justified in whatever way, but the court has already deemed that they can't be the trustee. You need to be the person because they can't be trusted to do a good job. But at that point, you wouldn't want to take that case because, number one, someone's attacking you and you don't know what they're going to do. And it's not a happy time for someone to hate you personally, right? Nobody wants to be hated, number one. And number two, you have to spend their money. So yeah. I get it. I don't want to be a part of cases where people are hurting themselves. I out of every 100 clients that call us, we maybe take 25. We turn away 75. We just filter them. We say, hey, look, I'm not your guy. Someone calls and they say, hey, can you help me control my mother's money? She can't make decisions. By the way, I want it to come to me. No, thank you very much. Go somewhere else down the street and try to steal your mother's money. It's not what we do. But then other situations where they come in and they say, hey, dad died. I'm the trustee. My very first question is, your siblings, are they happy with this? No, they're very angry. Maybe I'm not the right case for you. Maybe I'm not the right attorney. Maybe you want to go to the attorney who likes the ugly battles. There are lawyers who love the ugly, dirty, messed up, screwed up cases. Not because they're bad people, but they kind of thrive in that environment. They're as a characteristic, they like the challenge. They're very disagreeable. They are okay being the bad guy. So then, and they like to stand up to bullies. I remember in a case where there was a trust gone wrong, and I was representing the trustee, but a bunch of the beneficiaries went sideways, and they just started attacking for ridiculous reasons. So I called a friend of mine named Matt. You probably know Matt. And I said, Matt, can you help me? And he said, I don't like bullies. I'm going to do this. So he took it on and he beat the bullies. I'm not very good against bullies. I'm just not. I hold my line, but when it comes to people just being aggressive, not that kind of guy. It seems like you and I are the same mentality.
Yeah, I kind of think that way too. I don't like bullies either. I'm from the East Coast, right? So we don't like bullies. We're very, I don't shy away from them, but at the same time, I don't want to have to deal with it, really. Yeah. I'd much rather deal with somebody who really needs me. So that's where I have very much focused my business now towards just the folks that are seniors that really need the help. Like today, I just got a call from somebody in San Francisco. Her husband fell. I'm their successor trustee, but she didn't know who else to call. And she's flustered and she's just worried about everything. And so I got her in touch with somebody else because I'm not in San Francisco. So those are the kinds of cases that I really like because it's somebody who needs me or who really needs the help. And that's more, for me, more gratifying. I feel better as a person if I'm helping somebody that really needs the help instead of somebody that's screaming because Sister Mary got more money than I did in a trust when Dad died. And it's not their money. It's Dad's money.
It's Dad's
That's
money.
the other thing. Dad's money, and yet everybody's fighting, and they think that they can do it better and that they know what they're doing. That's the other thing that's really funny is when you're trying to, I've had to deal with a lot of real estate and deal with realtors and I've had to sell, over the years, quite a bit of real estate. And somebody says, oh, I used to do real estate and I'm in LA and I know what the market is. I know how to do real estate. I'm like, yeah, okay. And then they want to tell you don't paint it. Don't do anything. The house is I've had this one. The house is going to sell itself. And then when the house didn't sell itself and it sold for less than what it was appraised for, then they got mad at me. I'm like, well, you wouldn't let me even paint it. So we got into, there were a lot of dysfunction. That's when a good attorney comes into play because that's where, certain attorneys that can deal with this can then be a mediator or step up and say, we're going to do it X, Y, Z. And so that always helps. Doing the notice proposed actions or meet and confers and things like that.
Yeah.
Again, that's where I feel like I've gotten to know the law so much more than I ever wanted to doing this.
I think there's something that you said which is really key, and I'd like everyone who's listening to hear that you do not have to take their case. You as a professional do not have to take their case. I've said today, I don't have to take people's case. And so that doesn't mean that there isn't someone out there who can. But the most important thing that I want to say to all the listeners is to say that there are certain choices that will make a lot of professionals shy away from you. And when you have fewer people that can help you, the cost goes up because now they're a premium product. So if you want costs low, you want to behave in a way that most people will accept. And if you need to win, that's totally okay. You can win, you can try to win, but the cost goes up dramatically and it goes up significantly. Just a simple explanation here, that case where I talked about the 4 kids, the original fee estimate was going to be about $10,000 to administer a house, which was worth $1.1 million or something like that, which I think is a reasonable amount given an attorney's fees and the amount of work that you have to do. The end fee, all of the attorneys charged more than $80,000. $80,000 because there were different attorneys going back and forth and the children stopped talking. So it became a dramatic game of telephone. So the child would tell the attorney one thing, the attorney would tell the other attorneys one thing, those attorneys would go to their client, and then it would go back and forth. So rather than brother talking to sister, sister talked to sister's attorney talks to brother's attorney talks to brother. And now you have miscommunications because you have so many different transactions. Plus, you're charging 2 attorneys to say one message, and you don't just charge it once. Now, brother's attorney talks to brother's attorney talks to sister's attorney talks to sister. And if you have a negotiation, you're going to go back and forth 5 or 6 times. Suddenly, you're paying 12 hours of attorney's fees at $500 to $600 to have 2 conversations. Yeah, it's going to rack up. And so
the other thing is it just takes so long. It takes so long to get anything done. And, people are crying that they want their money. I mean, I've got a probate case right now. There's a bunch of people involved. They want their money. And yet when I try to do something, they object. I'm trying to give you a distribution. And yet there's these objections. Because they don't want, this person doesn't want that person to get X. And then it becomes this ridiculous, drawn out process that just takes forever.
You can't have it both ways. Simple, just the simple consequence of needing to be right and needing other people to be wrong means that if the other person doesn't agree, so if a brother is attacking a sister, he says, I need to be right and you need to be wrong. If the sister disagrees, now everything goes slower because a judge, when we're talking about this, we're talking about what goes in front of the judge. Always, the judge is the final decision maker. So everything that I do is gauged towards what's going to happen when you go to the judge? If you need to be right, then I need to phrase the conversation in a way so that the judge will be convinced that you might be right. And it just takes a long time because I have to make sure that all of that is prepared. You can't just say, Elijah, do X. The answer is I need to do X times 12 or whatever it is, because I need to prepare the case correctly so that if someone does take this in front of the judge, you don't look like a jerk. Because you're going to be in front of one judge. You're going to be in front of one judge. And if you look like a jerk once, the judge isn't going to believe you again. I've seen it happen so many times. This funny story is that I went into court, and I'm well known in the local courts with the local judges and the staff. And we were going to lose a case. We were absolutely going to lose. If the judge had liked this attorney at all, we would have lost up the front. But the judge didn't like that attorney. That attorney had misled her in the past. And so rather than listening to this other attorney's argument, she looked at me and she said, Mr. Keys, what do you want to do? She didn't trust the other person. She trusted me, who is the opponent, and she knew that I was going to lose, but she trusted me to give her the honest statement, and I guided the case as I wanted to guide it. Your Honor, I think we should do this. And she said, great. We did this, and we slowed things down by a couple of months, and we were able to get more money. The answer is just be honest. Be honest and direct, because if you're not, you are going to lose more. It's horrible. Some people think that if you could just hear my statement, hear this all the time. If they could just hear me, then they would believe me. And the answer is no, they won't. I'm not that special. You're not that special. I wish they were. I really do. It's just a persistent delusion, I think. I don't know how to fix it.
Well, it's funny because as you're talking, and one of the things I did want to bring up in our conversation was accountings, because that's the other thing that I do. And I'm actually leaning my business towards doing only accountings now and only helping, the people that really need the help. But that's the other thing, is that people don't understand. You start suing each other, you start getting into that kind of litigation, right? Then some attorney's going to say, I demand an accounting from the trustee, brother A, sister, whatever. And then they go, oh, well, what's that? And then that creates a whole new thing, and it creates a lot of delays. Now, I have seen we do a lot of accountings. I've had way, way more accountings than I've had of my own cases. So I have seen the gamut of bizarre things happen, and I've seen people commingle funds and then we've had to extract the commingling and try to extract out, what somebody had the AB trust. And so they put all the money, what they did was they put all the income into one trust, and all the expenses somehow got paid out of the other trust. It was very strange. It was really weird. But they were supposed to be 50-50. Everything was supposed to be 50-50. And they just kind of and we're like, and then I'm trying to tell, we're working with the attorney because it's the attorney's client. And so we're working with the attorney who's saying, look, if you think this guy should stay as trustee, okay, but he's really screwing up, right? So that's what comes out in the accountings. Is it identifies whether somebody is honest, and maybe they just made a little mistake and put money A and B, whatever.
Sure.
They put $100 in the wrong account or something like that, and then you have to put it back in the other account. But we've done that where we've had to really untangle a lot of mistakes that people have made and come up with a distribution schedule and a reconciliation schedule and things like that. A lot of lay people, and this is one thing I think people that are listening to the podcast need to understand, is as if you're a lay person, if you're not a fiduciary, you have to really pay attention to the records. Every penny that you spend, every penny that comes in, you have to be extraordinarily, think about you're going to be audited every month. And you need to pay attention to exactly where all that money is going, where it's coming from, and where it's going. It can be very intense when you've got litigation and you have to go into court and the judge is looking at, okay, where did you spend the money? And they're looking for, did you pay yourself? Did you buy yourself a car? Did you, are you giving money to your daughter when you shouldn't have been giving money? So it's a really interesting concept that people don't understand. That's actually part of the law, that you have to do an accounting unless it's waived. And so there's something that, would be nice that that lay people need to understand, so that should they have to hit litigation, that they know they've got all their ducks in a row, they've got all their assets set up, they know where all the money is, they know exactly who they paid and why, so that all that is covered and they don't have to be second guessed. So nobody second guesses their administration of the trust.
Yeah. I think for an accounting, for each individual transaction, regardless of whether it's 1 million or 1 penny, you need to be able to prove what was paid, who was it paid to, when was it paid, what was the purpose, and a receipt. And you need to be able to show every single detail of every single transaction. Some people say, that's ridiculous. I've never had to do that before. And the answer is, well, you don't have to with your own money. It's your stuff. But when you're a trustee, it's not your money, it's other people's money. Would you ever accept a statement from a bank saying, we think that you have $35,000, but we're not really sure because $400 of that might be there or it might not? You would never accept that in a million years. The judge won't accept it either. If you are a trustee, you are responsible for someone else's money. It's not yours. You don't get to waste their money. That means you have to show how much you paid, when you paid it, why you paid it, who you paid it to, the method of payment, and you need to show a receipt. And I had a conversation with someone the other day. She was being audited by the Social Security Administration, and they said, bring all the trust records. And she said, I don't have any records. I paid the money to myself, and then I spent the money for the beneficiary. And I said, well, bring what records you have and do your best. And she said, well, what am I supposed to track? And I told her, you're supposed to track this. And she said, every single transaction. And I said, yes. Every single transaction, because it is not your money. It is someone else's money. So if anybody listening to this, if you can take one thing away as a trustee, understand that it's not your money.
Yeah. And to the penny, we get, I've had these conversations with other people that do accountings, other fiduciaries. I mean, you have to take everything into account and you have to make sure every penny is accounted for. And now when you have things like investment accounts, you have a Schwab account or you have a Merrill Lynch account and you have stocks and bonds and, oh my God, that gets really complicated. And it's not like doing your taxes where you get a 1099 and you give that to your CPA and you say, okay, this is what the trust made. It's not like that at all. You have to track every dividend, every penny of interest. Anytime there's a merger, a lot of times you've got stocks. Let's say you have Google buys something because they're always buying somebody. If you had stock in the thing that was bought, now you've got to combine that. And there's a whole nother avenue of managing that you have to track. You have to track that in the accounting. And it gets tricky. It gets very, very tricky.
Yeah.
Spin-offs, mergers, stuff like that.
Yep. If you own shares in Waymo, which was purchased by Google, I believe. Mm-hmm. And Waymo became Google stock, Alphabet stock, right?
Yeah.
So you have to show that. And you have to show every time that you sell Amazon stock, how much money you made, whether you paid capital gains or whether you claimed a capital loss. And then if you're repurchasing things. So oftentimes when people come in, if I know that there's going to be an accounting and they have a money manager that's buying and selling things like crazy, I tell them to stop that, because we're going to have to report every single one. And if you're making 10 cents on a transaction, it's going to cost me $100 to describe that transaction. So you're making 10 cents and you spend $100 to describe the transaction to the court. Imagine buying and selling stocks is very efficient now. Courts are not. You're buying and selling stocks to try to make pennies on the dollar. Fine. But now you have to describe those transactions, and the courts are manual. Courts are manually done. Someone is sitting at a computer manually typing these numbers into a computer. There's programs that you can use, and I'm sure, Susan, you use them. But the default, most people do this manually, and it is just time-consuming and expensive.
Very time-consuming.
Stop.
Yeah, it's very time-consuming. Yeah. One of my very, very first accountings that I did for this fiduciary friend of mine, they had five separate Schwab accounts. I think it was Schwab, but it doesn't matter. In each account, they had 50 securities. 50 securities in each account. And each account, they would have had 50 to 100 trades in that one account. So we had 5 accounts with 50 trades per month. And so you had to do an accounting for the year. It was tremendously long. I mean, it really was. It was impossible to balance because it was so crazy. I took over from another another person who does these, and just two heads together, it was almost impossible. It was impossible to handle.
You have 50 trades in 5 accounts with 50 different stocks, right?
Mm-hmm.
So 50 trades, 5 accounts, that's 250 trades per month times 12 equals 3,000 trades.
Yep. We've had
3,000 trades. You have 3,000 individual lines in each trade, just so you know. Each trade requires an entry on 3 different sheets, and the trade then requires you to record probably 6 different lines on different sheets. So that's an extra 18,000 lines in one accounting overall. Just stop buying and selling.
Yep. Somebody's making money on that, but it's not you, right? It's not.
Well, at the end, the person that's making money on that when someone dies is you and me. You're making money because you're spending time, and I'm making money because I'm reviewing the thing. And it has to go through at least 4 or 5 sets of eyes. And then when it goes to the judge, the court investigator is going to review it. And then the probate examiner is going to review it. And then if it's really hairy, then the court attorney is going to review it. And then they give it to the judge with recommendations. So every time that there's a trade, if this is a trust, just remember, every time there's a trade, it's going through at least 7 different eyes to review it. Just do the minimal amount necessary.
Yeah. We've had accounting where we have had thousands of lines in just the investment accounts because it's so the word that we use is churning. It's just churning, constant changes in the account. It's crazy.
Yeah, it is crazy. Well, we've talked for quite a while today, and I always like to allow our guests to say something that they would like people to hear. I know you've said a lot of piece, but if you had one thing that people could walk away from the episode today, what would you want them to hear? What would you want them to know?
Get a good attorney.
As a trustee?
As a trustee, get a good attorney. Well, get a trust. I mean, I have friends that don't have trust. I mean, even if you don't have a lot of money, if you have real estate, you've got something there that's worth something. Get a trust. For heaven's sakes, get a trust.
Yeah. There's a book that I leafed through called Too Big to Fail, which is about a series of banks. It's about the financial crisis years ago. But the banks were bailed out because they would cause this incredible damage to the economy. And in this series of transactions that saved the banks, the government was there to make sure that the financial system stayed up, and the banks were there to make sure that people still got access to their money, even though that didn't work so well. But when you're dealing with a trust, it's very, very different because it's not about an individual's ability to access money. It's not about an individual's ability to conveniently access things. It's about making sure that things are safe and secure. So a trust is like a safe. It's like a safe that you have in your house, in your garage or wherever, and it's bolted to the floor. And if you have a safe, but you haven't put stuff in it, then you have your gold bars next to the safe sitting on the ground. It doesn't matter. And if you don't have a safe, then you have your gold bars sitting on the ground, and it doesn't matter. But when the next person gets access to that safe, they have a security guard who's watching them, and that's the judge. And they need a good person to tell them, this is what you need to do, and this is what you not need to do, and then protect them. So I think just for an analogy from a safe and a security guard, you need a good safe, you need to operate it well, you need a good attorney. Some people won't do that. That's okay. But they run the risk of having Susan step in the future because they didn't do it right.
Yeah. And if you are a trustee, please make sure you pay attention to your records. Like towards the end of this, it's so critical. Just another little word. I did an accounting for another cute, adorable lady, and the courts made her go back to 2012. This is last year, 2013. No, 2007. They wanted her to go back to 2007
She can't.
Why, I don't know why the courts would ask her to do that anyway, because you can't get those records. But so we had to really, really work hard at pulling out old receipts. And, I was given boxes and I had to go through boxes to try to figure out what was going on.
I've done that before.
Please, please pay attention. Get yourself organized. Make sure you follow what exactly is going on and keep records. Keep really good records. Yes.
Base thing to do is to save bank statements and set up some sort of a accounting software, QuickBooks, Quicken, Zona, whatever it is, to just keep records. And that's kind of the baseline of what you need to do.
Baseline, yeah, absolutely.
Susan, it's so nice to talk to you today. Thank you so much for coming on our show. I was a little bit late today, so I apologize about that. It's a vacation day, so I lost track of things, but you're always so gracious and so kind, and thank you so much.
Thank you. Well, thank you for having me.
Of course. You're
Thank
very
you
welcome.
so much, Elijah. All right.
Yeah. All right. Well, we'll talk soon. Thanks so much.
Okay. Bye.
You've been tuning into The Keys to Your Legacy with your host, Elijah Keys. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, keyslawgroup.com. Thank you for your positive